Justice Kavanaugh?
I'm interested in picking up on those questions and what Colorado's position on the First Amendment could lead to, not what you would do based on your representation, but what your theory of the First Amendment could lead to, and thinking about the proper analogy to a website designer. So I've been thinking about a publishing house that says we're not going to publish, we support pro-choice positions, we're not going to publish books that support pro-life position, or that we support same-sex marriage, and we're not going to publish books that take a different position on same-sex marriage. Does the publishing house have a First Amendment ability to select the kinds of books that it will publish along the lines of my hypotheticals there?
Of course it does, and I think a publishing house is not a public accommodation for precisely the level of selectivity and choice that it goes into, just like the court recognized in Fulton.
Right, but if it were a public accommodation, it would still have a First Amendment right, correct?
Yes.
Sure about that?
Yes, because what all the public accommodation law says is you can't turn someone away because of who they are. And it would be different if your hypothetical was they will not publish gay authors. If they were a publishing house,
right.
They won't
That's the distinction right there.
Yes.
You put your finger on it, I think. So the website designer is different from the publishing house. How?
Because the website designer is refusing to publish gay authors, using the publishing house example. They are saying, I will not provide this service to someone because of who they are, period.
They say it's because of the message.
I understand, but they define the service in a way that excludes people based on who they are, and that violates Colorado law. And to the extent there's some incidental impact on their message, it's the kind of incidental impact that this court held in O'Brien as to be appropriate, where a law is focused on conduct and not the message itself.
And I thought the amicus brief of Professors Carpenter and Volokh was fairly interesting. They supported the same-sex position in Masterpiece, but that they say they're on the opposite side in this case, and they say that the reason is because this case involves speech. They say a website designer is unlike a baker, and that Hurley, therefore, is the key precedent here. And they say there is no serious question, their words, no serious question that this case involves compelled speech. Do you agree it involves compelled speech?
No.
Okay. Even though they say there's no serious question that it does. You disagree with that?
We disagree with that.
Thank you.